Welcome to CC Partners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.
We're going to move into the Q&A section. A lot of you have posted questions in the chat box. We're going to go through some questions first that we had received before the program in our slides. So this will give you an opportunity, if you haven't put your question in the Q&A box, to please move over to the Q&A and give us the question there. It'll be a lot easier for us to find that question than to search through the lengthy chat that we've seen.
Rob, just before we do that, official transition to the Q&A portion, and I see you've got everybody's contact information up there. You mentioned at the outset, this is our 8th COVID-related webinar. It will not be the last, and it certainly will not be the last of the several we've had for the childcare sector specifically. This is kind of the tip of the iceberg of this whole reopening and what it might look like, and again, not to be alarmist, but what the alternatives might be if reopening ends up not being feasible for you in either the short, medium, or long term. And that's something that we're going to need to digest and absorb some more of the information that we expect to get over the next few days. And certainly everybody on this participating today is going to be getting information from their various professional resources, not just lawyers, but accountants, auditors, that kind of thing, and the sector. And we really encourage everybody to, keep your ear to the ground and share anything and everything with each other. As Amy has said, it's disappointing the way that this has come out for this sector. It's disrespectful, and advocating together and for each other is one way that we might be able to all come out of this. And I say we because I've been working hand in hand with many of you on this call and the childcare industry in particular for the last 15 years, pretty much, or close to. So to me, it's a very important thing, not to mention having my kids in licensed childcare as well. So stay tuned for upcoming webinar or two on, kind of the next stage of considerations for childcare. Sorry, Rob, I didn't mean to hijack your.
No, that was really helpful. I think you can see from both Amy's comments at the outset and also Charles' review of some of the materials that have come out. There's an enormous amount of information that we're still sifting through to educate ourselves, and that's been the case, I think, continuously during this pandemic as new programs have been rolled out, and we are trying to get information to our friends out in the various industries and our clients in particular. So it's been a challenge for us to keep up to date and to learn this material and to provide as much guidance as we can, even while the rules of the game have been changing almost on a daily basis, particularly at the beginning. And we're probably going to see that being replicated during this reopening phase. There will be different and new rules about reopening that will have to be adhered to, and all the things we talked about in terms of layoffs and recalling workers, and now the statutory protected leave for non-union workers. We're going to put those learnings into practice, and the rubber will hit the road in a very real way. Stay tuned for more programs that we're going to run there. I did receive prior to today's program, and we'll, I think, answer a number of the questions that are in the Q&A as part of these questions. So, question number one, I think we already answered. We had some discussion with Charles, Kelsey, and Amy about, as a child care operator, are we allowed under any law to make COVID testing mandatory for our employees? So I don't think we need to continue that unless someone's got a particular comment they want to add that wasn't already addressed. Enrollment of clients, students, children has decreased due to COVID-19. are we obligated to rehire everyone back? If not, do the staff that's not returning remain on the SERB or EI? I'm gonna, of Kelsey or Christina, that probably in terms of the in terms of the statutory protected leave, do you have any comments about that question?
So I can jump in here. With the protected leave, assuming that the employees in question are currently or previous to May 29th had been on layoff, they are now deemed to be on that job protected infectious disease emergency leave. And one of the key protections that comes along with that is the right to reinstatement. But thinking through the question here, I think one of the key issues is whether the enrollment issue is long-term. So for example, if the center opens in June and it's not expected that you'll get back up to full capacity until say August or September, one way to navigate that may be to have the employee remain on the leave until it expires, which will be 6 weeks after the emergency order is lifted. And from that point, return the employee to a run-of-the-mill temporary layoff in accordance with the ESA. So that then starts the 13 or 35-week clock again, or continues it depending on how much time has passed. So it's something of a complicated question and will depend on the circumstances to some extent. I see that the follow-up, if not returning, do staff remain on SERB or EI? I think that also comes down to timing. So if the employees are still eligible for SERB, that would be what they're receiving. If they've exhausted their SERB entitlements, they would transition back to regular EI.
And I think we've seen the federal government has extended the application of the SERB into October. So that may be, they may still have eligibility. So for the unionized workplaces, we're not talking about that statutory leave. We're talking about the usual recall layoff provisions of your collective agreement. So those would still be in place. So, well, I think we know the answer on seniority around the application of a collective agreement, but when we're recalling workers back to work in the non-union setting, do we have to respect seniority in the order in which we recall them? Kelsey, why don't you talk about that?
Sure, I'm happy to jump in there, Rob. I mean, short answer is no. When you're not subject to the requirements of a collective agreement that almost always have seniority as the default option for recall, provided, of course, that employees have the qualifications and skills and abilities to do whatever the job is that to which they're being recalled, you can do it based on whatever makes the most sense for you operationally. The caveat there being, of course, we can't discriminate on any human rights protected ground, but if you're talking about a particular room that has nobody in it and you don't need those teachers, you don't need to recall them. It's up to you as the employer to determine what is best for you operationally.
So, I mean, part of this question, the secondary question in this one is about a room having no enrollment. So I think that's a kind of an operational specific type of question for a larger childcare center. But I guess the same question would apply here in terms of who you're recalling and how you're allocating the children to particular members of your staff. Is that fair to say, Kelsey?
Yeah, I think part of it is, as Amy mentioned at the beginning, and then, I think we saw Karen's comment about, we know that there can be 10 people in a room, but as Amy said, we don't know what the ratios are. Under the traditional rules of the CCEYA, there's very limited mixed groupings allowed. And Amy feel free to jump in if you're still available as to whether or not there's going to be any information about that. But in terms of the rooms, if it's specifically broken down the way they are now, then there's probably not a whole lot of reallocation you can do unless they change how they look at the grouping for the purposes of getting people back in childcare under these new restrictions.
As far as I know, Kelsey, the CCEYA ratios remain in effect the way they are. Yeah.
Thank you, Amy.
So the last part of this question, and it kind of rolls into the next question, which is item 4, is can we leave employees on the SERB if we're not recalling them to work? And I think Christine has substantially answered that question. I think the one thing that I noticed in the news yesterday, we haven't seen any legislation yet, is apparently there's a draft bill that's being considered by the federal government about tightening some of the entitlement criteria around SERB, and I think it's really focused on entitlement issues with potential reopening of the economy, but also issues about people who've been receiving SERB who might not be eligible for those, and what types of enforcement processes the federal government might apply to that. So we can't tell our employees whether they're entitled to SERB. That is a decision to be made by the federal government. But if you're thinking about recalling employees and they refuse to come back to work, and we're going to come into that, I want Charles to speak to that next question. You should keep an eye on some of those changes in the federal government legislation, and we'll probably talk about that again once they may or may not come out. Because if you do offer work or an opportunity to people to come back to work and they deliberately refuse that opportunity, I can't foresee circumstances where that might impact their eligibility for SERB. So again, we don't have legislation yet. We don't really have much information except what we've seen in some of the news articles. So it's premature for us to fully comment on that. But Charles, can you talk about that question about the fear? And we've heard this, I think, throughout the entire pandemic. I'm afraid to come to work, or I've got my own issues with childcare in terms of finding somebody. How do we deal with those things in this particular industry sector?
Yep. So with the exception of the last one there, because I want to remain on SERB, which is never going to be an excuse or qualify someone for a leave of absence. You really have to, and you might actually have to go back to the employee and do a little bit of digging to get a little bit more information. The fear of getting sick, so there are certain situations where they will qualify for a leave. So they may come to you and suggest that they want some time off because they have a fear of getting sick. But the real reason might be because they're actually required to assist a family member who's in quarantine or whatever, with whatever it might be, so the necessities of life or just getting along in life. In that kind of scenario, then they may well qualify for a leave. And in that case, the time frame to accommodate that request is it will be driven by the type of leave that they qualify for. So if they do qualify for the new infectious disease emergency leave, I believe the legislation says that essentially they can just go on the leave if they need to immediately, and then they have to inform you and provide evidence reasonable in the circumstances within a reasonable time. So in those kinds of cases, you really just try to get to the bottom of why the request is being made, because employees don't always have the foresight or don't always know what the specific legislative requirements are. So just don't be afraid to ask certain types of questions. And then if they do qualify for the leave, basically the best guidance I can use is just try to be as reasonable as you can. In the second case there, sorry, go ahead, Rob.
No, I think I think the practical component of it is an important part to consider, even in the order in which you're asking people to come back to work. If you know that there are some of these other considerations that are whether we think they're legitimate reasons to refuse to work, they may be very, very real to the employee themselves.
Yep. And then with the second one there, the childcare issue. So that could be an infectious leave issue, or it could be a human rights issue, or it could be both. So again, in those cases, it's the best thing that you can do is really just ask those first few questions to try to get to the bottom of why it is that they're seeking the leave, why it is that they need it. And whether they even qualify may not even be a question that you need to address right now. If you're in a position to accommodate it and it's something that you can do anyways, then you might just consider granting it kind of gratuitously. But if you are in a position where you wouldn't qualify it unless they, or you wouldn't grant it unless they could prove that they qualified for it, then you have to look at what it is, which kind of leave they're qualifying for, whether it's under the ESA or the Human Rights Code, and then take your cues in terms of accommodating that request from those two things. So if it's the ESA leave, then it's kind of, they can go on the leave and they can inform you and provide evidence whenever you want. If it's human rights, then all the principles of accommodation will apply, and you can try to work with them to try and find other types of accommodations sometimes before they go off on the leave. It all kind of depends on the situation. So if you have a specific situation like that and you're not sure what to do, it's probably best to get specific advice on that.
That's very helpful. So, I mean, just before we leave that point, Christina, when you were talking about the application of the infectious disease emergency leave provisions to what had been previously been layoffs or reduction in hours, I understand from that regulation that in that circumstance, the employee doesn't have to ask for the leave. It's deemed to be a leave. But in some of these other circumstances that Charles talked about, needing to provide child care, perhaps elder care, or being sick themselves, or being required to be in quarantine or in self-isolation, those are items where the employees are required to request the leave, are they not?
That's correct. So I think there can be a distinction between the deemed leave, which is for those employees who have been off work or who have seen a reduction. And, on the other hand, if you have an employee who has full-time work available to them or their normal hours available to them, but for another reason, say childcare, elder care, need to access the infectious disease emergency leave. So in those cases, they would need to request the leave.
So even if the emergency leave doesn't apply to them in that circumstance, and you have work and you're asking them to come back to work, is there any strategic value to granting them a non-statutory leave of absence versus continuing or beginning a layoff at the end of the infectious disease leave?
So if I'm understanding your question correctly there, it's once they've run the course of the infectious disease emergency leave,
Right.
Or if they haven't been deemed to be on that leave and they're coming to you and saying, listen, I need some time off. There is always the option for the employer and the employee to enter into an agreement that the employee take some unpaid leave, set some parameters around that. That's certainly doable, and if it's a unionized environment, certainly take into consideration how that might work under the collective agreement. And one of the benefits there is if you have an agreed leave as opposed to a statutory leave, if you had been continuing benefits, perhaps you can have an arrangement with the employee that it's no longer continued. Perhaps the length of time works out, or the timing. So once the infectious disease emergency leave is no longer available, you may still have employees who need to be off work for reasons that may be related to circumstances that otherwise would have given rise to the infectious disease emergency leave.
Okay. So pretty case specific approach, and I think Charles' comment about that is really important, that once you get to that stage, it's probably best for you to gather the evidence and seek specific advice about what to do with that particular situation. Now, on that next question that we have, I think we've answered the question about enrollment and the need to keep staff or not keep staff. But we did have, in addition to the SERB questions, we did have a few questions in our chat about the Canadian wage subsidy and whether or not that might be impacted in terms of when we open, or whether or not we have the enrollment to keep employees. So maybe, I know Charles, you're the CEWS expert at the firm. So what do you think about that particular question?
Yeah, so I saw a couple different kind of iterations of wage subsidy questions. So what I'll say generally, and this may answer your question, it may not, feel free to follow up if it doesn't. So it's actually, I was commenting to someone today, it's hard to believe we're actually almost at the end of the original wage subsidy, the length of time that it was actually proposed for. It was mid-June, I think.
Right.
So what we've heard from the government is on May 15th, they announced that they were going to extend the wage subsidy program to the end of August, but they didn't announce, so for example, they had these specific rules about deeming eligibility. So if you qualified for the one period, you automatically qualified for the next period. So they haven't said whether or not that's going to continue on for the continuation, or if you qualify for the third period that we're in now, whether you automatically qualify for the first period of the extension. What they've said is that on May 15th, they were going to take a month to consult with businesses, figure out what kind of changes needed to be made before they announced anything. So we don't have any information yet on what, if any, changes are going to be made, or how the next period is going to connect with the first period. But I would, so it's the, what is it, the 9th today, 10th today. I would expect that we would hear something within the next week or 10 days about how the wage subsidy is going to apply in these situations. So I know that probably doesn't specifically answer some of the questions, well, but I don't think we can.
Yeah, I mean, this comes back to some of my earlier comments that we're forced to make it up as we go along to a certain extent, because the rules are rolling out in piecemeal fashion, and that's understandable given the circumstances. But one of the things we did see at the beginning of the wage subsidy was that the eligibility criteria for revenue in the month of March was a loss of 15% versus 30% in the subsequent months. So, you know, I could, although we don't have guidance, I could certainly envision a similar kind of roll back into active operation as you start your business up, that those targets might be different, and they might be rolled out differently based on region or industry, depending on how we get back to business. So it's going to be a complicated adjustment, I would think, unless they just keep the same criteria, in which case this question number 5 is a very pertinent question about how do I bring employees back for reduced, when in a situation with reduced revenue, when I need the employees to handle the reduced number of children, but I don't have the revenue to pay for it. And even Amy's comments at the beginning that we're not getting any increase in the funding from the government, even though we're being expected to layer on a number of additional pre-opening and continued public health measures as well. So there's lots to talk about, I think, going forward. Question 6. Childcare gets a grant from the province, and we receive the portion from January to the end of March, and usually it needs to be paid out to qualified staff within 60 days. Staff are currently on SERB. On SERB will paying them the grant affect the SERB that they're receiving? Sorry, I kind of botched that reading. Kelsey, is that something you can address?
Sure, Rob. I mean, essentially, and I don't want to steal from Charles's bailiwick here, but because I've leaned on him for SERB specifics, but as he mentioned, the top-up plans available, the sub-plan doesn't work for SERB. But what we do know about SERB is that as long as the supplemental income being made by an employee receiving SERB is under $1,000 in the SERB entitlement period, it will not affect their SERB payments. So if the grant payout portion is less than that $1,000 for the 4-week period of that SERB entitlement, then and keep in mind it's all income for that employee. It's not necessarily just from you as an employer, but if that's the only thing coming to them, then keep it under $1,000 and they're fine.
Or even if there's a time frame to pay it out, I mean, you could certainly you could line up the payment of that grant portion to assist employees who will remain off work and would otherwise have been disentitled because they received it.
I mean, the other part of it is the 60 days going to be strictly enforced, and who's going to enforce it right now? So if you're worried about staggering payments, you may be better to act as you see fit and beg forgiveness than to seek permission. Not that is legal advice in any respect, but.
Yeah, the only other thing I would add, Kelsey, is, and this is kind of a technical legal argument, but I'll throw it out there because that's kind of our job, I guess. The SERB payments, the way that the legislation is drafted, I believe the exact phrase is employment income in respect of the period of time that the SERB benefit is paid. So if this is money that is from a period of time earlier, but it just happens to be paid out at a time when someone was receiving SERB, there may be an argument there for the employee to say that this is not income in respect of a SERB period. But at the end of the day, too, I know obviously you guys are concerned about making sure your employees are okay and getting everything that they can, whether it's a government benefit or not. But at the end of the day, it's do your best to fulfill your obligations, and whether there's a SERB payment or whether there's a payback obligation really is something for them to deal with later.
Well, this next question, I'm going to ask Christina to speak to it, but I think I'm going to read it, but I'm going to give my interpretation of what the question is actually asking. It says items that we need in order to move forward with opening a staff survey questionnaire on their ability to return to work, health, childcare, etc. So we did talk in one of the other questions we've answered about issues that employees might raise that would be a barrier to their return to work, including those that are that fall squarely within the basis for a continued infectious disease emergency leave. But one of the issues here that I think is identified that I think may have a different meaning is an employee raises a health concern for return to work. And that might be a general disability issue that needs to be accommodated. But one of the questions I've had from clients specifically is, I feel that I'm at greater risk of the worst outcome from COVID-19, and I don't want to come to work because I have one of these pre-existing conditions that have been identified in some of the early science. How do we deal with those types of either refusals or accommodation requests on reopening?
Sure, Rob. So I think just commenting on the question as it's written there to start, I don't know that I'd suggest a formal questionnaire or survey asking about health concerns or childcare obligations. My concern there would be if, for example, as the employer, you get back 10 questionnaires. Some employees have indicated either a childcare obligation, an underlying health issue, but haven't specifically indicated that they are not willing to return to work. And then you as the employer decide, okay, 1, 4, and 6 are healthy and have no children, they're coming back to work. I wouldn't want to open the door to a potential claim there of discrimination. I think clear, consistent communication with employees is always going to be the best bet. And when you're discussing a return to work, really have that open line of communication to say, listen, is there something I, as the employer, need to know that would affect your ability to return to work? And let the employees raise it as they would if there's something going on. And that way you're not in a position where you as the employer are asking for confidential medical information when the employee hasn't offered it as something that needs to be accommodated. So just to be mindful of that. And then the second question there of employees who are concerned either because of an underlying medical condition or some other disability about their ability to return to the workplace, the risk that that poses for them. I think in that case, as an employer, the duty to accommodate is triggered, and I think you need to take the steps that you ordinarily would if an employee is saying that they can't come to work. So I think first, it would be some medical information and documentation. So I want to be clear that for the infectious disease emergency leave, employers cannot ask for medical information to support an entitlement to that leave, but this is separate and apart from that. This is a request for accommodation because of a pre-existing disability. In that case, I think you can go through the accommodation process as you normally would. And, it may be that the employee is saying, I can't return to work at all. And you as the employer are saying, okay, I hear you. I see the documentation that you've given me. How about this alternative solution where perhaps we put you in a low risk area? Maybe you can't be out front with the children and all their germs, but perhaps there's something else we can have you be doing where you're still engaged in productive work, still in the workplace, but your risk is minimized to the extent that it can be. That may take the form of providing PPE for that employee. If it's something related to, say, a clinical anxiety about returning to the workplace, maybe a graduated return to work. So I think just making sure those procedural steps are taken and really just not taking a hard line in any one instance as you're evaluating employees and refusal or a hesitance to return to work.
That's very helpful. And again, I think once we roll into actual reopening scenarios, we're going to have an opportunity to look at specific cases with each of you when you need that assistance, but also undoubtedly we'll come back and have yet another program to talk about those issues, and probably more than one program. A lot of the questions that are in the Q&A, I think we have answered. There was a question about the Canada Emergency Wage Subsidy around decisions to postpone opening until September, which might be the normal timelines for some of you. Charles already pointed out that the wage subsidy program right now has only been extended into August. So it was extended beyond the original June timeframe. We don't right now have a program that's been extended into September. So if that remains the case, there will be no wage subsidy program for you when you reopen in September. So that's something to think about, even if you're thinking about delaying your preparation for preparing for the reopening, getting your sites ready in terms of meeting those guidelines. You might want to think about whether some of that work can be done in a time frame that's consistent with when the wage subsidy is available to you. But again, as Charles pointed out, we're going to get some more guidance, hopefully, in the very near future about how the wage subsidy would be applied during a reopening phase, and perhaps we'll be able to give you more information about a further extension if that actually is provided. One thing I've noticed in the press comments about the SERB benefit is that I think the federal government is also probably getting a little bit concerned about the cost of some of these programs. So, their tolerance for generosity, our generosity as taxpayers, will ultimately reach a limit at some point. So we have to be aware of that potential. Kelsey, here's a question. If the staff is required to quarantine, does the employer have to continue salary and benefits during that period?
No. absent some kind of other agreement or entitlement in an employment agreement or potentially in a collective agreement for unionized friends, there is no obligation under any of the amendments to the ESA or any of the programs in place at any level of government that would require an employer to otherwise pay someone who's not working.
Someone asked us a question, if we have a service agreement with the city, can we shorten our day? To me, that sounds like the kind of question I might want to see the agreement before giving comment on. Does anybody have thoughts about that? Or do you agree with me? Okay.
Yeah.
We can't interpret the terms of an agreement, obviously, in a question like that, but I guess it really depends on what's in that language. Christina, sorry.
Oh, no problem. I actually would like to just jump back to the last question.
The quarantine pay?
Yeah, for the quarantine pay. So the one nuance I would add to Kelsey's answer there is if it's a circumstance where the employer has been providing benefits to the employee past May 29th, and they are now quarantined, they would be entitled to that infectious disease emergency leave. And because it's a job protected leave, there may be that requirement to continue benefits. Salary, no, it is unpaid, but benefits, perhaps, yes.
Good point. Thanks for that clarification, Christina.
Right, and I guess there's distinctions too between the layoff, the conversion of a layoff to a deemed leave versus leave for the other reasons that we discussed that pre-existed Reg 288-20. So it's a lot to keep your mindset on because there are so many threads that you can pull. Just looking to see, because we're now getting close to 2 hours of our program. I think
I do see our numbers dwindling, but still amazing participation and attendance today.
Yeah. So obviously, a lot of these questions are things that are very much at the minds. I think we've. Sorry, I'm just looking at one of these questions in the Q&A, and I haven't even gotten into the chat group. That's why I suggested if you had a question, put it in the Q&A rather than in the chat. But I think, to me, this probably looks like a logical point for us to conclude our program. There are some case-specific types of questions, and I know that we're going to come back and have another program specific on how do you go about the reopening. So I think we'll probably pause at this point, let you all catch your breath. You can all run back and read all the government support documents if you haven't already read them. And I want to thank everyone for sticking around as long as you have. And if we didn't get to some of the questions that you asked, stay tuned for future programs. I think we'll probably be able to answer many of them. And if you have specific cases from your workplace, feel free to reach out to any of us for assistance in working through those special issues. Again, a reminder, our programs will be, this program in particular will be available on our broadcast tab. So if you want to go back in and look at it again, if you want to even just roll through our slide presentation and turn off the sound and don't listen to us, it's going to be there probably indefinitely for the foreseeable future. And that will wrap it up. I thank everybody for joining us and my co-panelists, and specifically Amy O'Neill for her additional support at the beginning of our program. That ends it. Thank you.
Welcome to CCPartners, the employer's choice. We provide expert legal and strategic advice in all areas of labor and employment law. By working closely with our clients, our experienced team delivers pragmatic, proactive solutions, resolving many issues before they escalate. Get to know us better at ccpartners.ca.